This course is best geared for solo practitioners and people in small practices. And what we're going to be talking about this evening are the terrible decisions that attorneys make, decisions that in the old days used to wind up in John's lap. They are decisions that are characterized by the following consequences. Number one, they cost you money out of your pocket. Number two, they drive clients away from your firm. And number three, they often get you jammed up one way or the other with an ethics complaint, something that could be very easily avoided by just not making some of these basic errors. We've done a study on the main mistakes that individuals make in the private practice of law in New Jersey, and what we're going to do is talk about those errors, talk about the ethical ramifications and practical steps that you can take in your own practices to avoid these errors, either through negligence or even sometimes through purposeful conduct. What I wanted to do was start, we're all kind of business people here. This is a class, as I said, that is really geared for private practitioners. And as you all know, if you're in private practice, and it doesn't really matter what you do, if you're doing personal injury work or criminal work or real estate, it doesn't make any difference. Every time that you've completed work with a file, and if you want to stay in business, at some point you're going to have to replace the client whose file you've just closed with either one or two new clients coming in. In order to accomplish this the most efficiently, we utilize in practice, either whether we know it or not, this concept called the client-to-client cycle, all right? And I want to kind of illustrate what it's involved. But this is fundamental to having a profitable law practice in New Jersey or any other place, but especially in our state. And the whole goal for us tonight is to get an understanding of how the client-to-client cycle works, and then see what we can do to make it run efficiently. In other words, get the most clients in, spending the least amount of resources possible. All right? Now, there are essentially four phases to the process of the client-to-client cycle: client acquisition, client maintenance, client preparation, and ultimately client advocacy. So if we start over here with number one, this is the client acquisition phase. This would involve all the things that you do in order to attract clients to your law firm. It may be in terms of direct mailing pieces, it may be by advertising on television, it may be just through word of mouth, or attending all types of things that would attract clients to you. There are certain ethical constraints on your ability to do that, but that's really a little bit beyond what we're going to be discussing tonight. But the bottom line is that all of us are involved in this concept of trying to attract clients to our firm. The key aspect of client acquisition deals when you go through the process of getting the client basically to agree to be represented by you. And it's very important, just from a marketing standpoint, forgetting ethical issues for a moment, that you kind of very early on in your relationship with the client determine what is going to meet the client's needs. What are the expectations of your client with respect to whatever legal problem you're going to be representing him on? At the end of the day, ideally, in order to have a satisfied client, what you'd like to do is either meet those expectations or, even better, exceed those expectations, because that's going to virtually guarantee you're going to have a very happy client at the end of the day. Our studies, and this is from a marketing perspective, have found that the best type of client is the one who's going to come out and refer business to you. We've done statistical studies kind of preparing for this and found kind of an interesting fact. There is a limitation territorially in terms of how far people will travel to come to your law practice, depending upon how they find out about you. In other words, let's say you are one of these attorneys who sends out solicitation letters. Typically, there's about a 5-mile radius from your office where you can attract clients as a result of a random type of mailing. Beyond 5 miles, the statistical likelihood of them responding to it is dramatically reduced. For situations where you're utilizing other types of contacts, advertising in the newspaper, for example, internet advertising, the radius seems to be approximately 10 miles from where your office is. That's how far people will travel. What we did discover was there is no limitation on how far people will travel to come to your office based upon a mouth-to-mouth recommendation from one of your clients. All right. So if client A tells client B how great you are, what a great result you got, client B will travel from across the state to come to see you to retain you for those services based upon the strength of the mouth-to-mouth representation about how great your firm is. So, having said all that, you understand how important it is to meet or exceed the expectations of your client. But these are established very early on in the relationship you have with your client, and it's important that you, number one, not oversell what you're going to be able to do, and number two, make sure that you give your client, and this is from an ethical standpoint, accurate, reliable information in terms of what you're going to be able to accomplish legally for that client. A perfect example of this would be, let's say, in an expungement situation. The client comes to you and wants to have a criminal record expunged. And you make a representation to the client that says, you'll be able to claim that it never happened, and the records will be destroyed, and they're not going to exist anymore, and nobody's ever going to know about it. Well, that's about like 1/5 legally accurate, all right? So it may be a question of inadvertence. It might be purposeful, puffing that the attorney's doing. But when you give a client that type of information, you're not giving the client legally accurate information. The client really can't make an informed decision as to whether or not to hire you as an attorney. That kind of gets you into a situation where you have some RPC violations when you're engaging in that type of conduct. So the client acquisition phase is really involved in two things. Number one, getting the client in the door in the first place, and number two, determining what the client's expectations are going to be, with the idea at the end of the day that you're either going to meet those expectations or, if you're really good at what you're doing, exceed those expectations. And setting the client's expectations is very, very important in this regard. All right? The next phase is client maintenance. These are all the things that you're going to have to do during the time that after this individual has decided to become a client to keep this individual happy. Many of the cases that we do go on for years and years and years, and during that time period, you've got to keep your client, reasonably satisfied when there are downtimes, in his case, when nothing really is going on. The number one complaint that seems to be around the state when there's issues between attorneys and clients, not necessarily rising to the level of an ethics violation, are communications issues. He doesn't return my phone calls. I write letters to him. He doesn't get back to me and things of that nature. Again, you want to be in a situation where at the end of the day, this individual is going to be referring to a business to you. So you really should have some type of system set up, just as a businessman, forget about the ethics part of it, to be able to effectively communicate with your client. My own advice to everybody is just email, and more email. Always have some type of email access that your client can exercise to get a hold of you. It allows you to respond in a very cursory way. It gives you a written record of when there was a query answered and what you said back to your client, and gives your client the perception that you actually are paying attention to his case and communicating with him on an ongoing basis. Again, the whole idea here is to kind of keep the client satisfied during this maintenance phase when there's not a whole lot going on. There will be preparation phases associated with it, though, depositions, interrogatories that have to be answered, prepping the client for trial, going over discovery and things of that nature, obtaining discovery. These are all very important parts of the working the case up, getting it ready for trial. And again, communication between you and your client during this phase is critically important. Now, the last phase is client advocacy, and this is going to be whatever you do to represent your client on the underlying thing that he's hired you to do. Might be a trial, motion, whatever it's going to be. Arbitration, doesn't make any difference. There's going to be some level of advocacy that you're going to advance on behalf of your client. And the key here is this, that at the end of the advocacy stage of the cycle, there's to be a role reversal, where instead of you being an advocate on behalf of your client will become an advocate on behalf of you and your law firm, because you were able to meet or exceed the expectations that you had established way back when during the client acquisition phase. All right? So the whole business is tied up in this client-to-client cycle. This is how you keep clients happy. This is how you keep new clients coming in all the time. And if you're really banging them out, you're going to replace one client with two. Okay? I mean, that's successful practitioners do that. What we're going to be talking about tonight are these grains of sand that you throw into this cycle that really kind of screws up this client-to-client cycle and prevents this process from being effectively and efficiently carried out. All right? So I want you to relate what we're going to be talking about to the client-to-client cycle.